Hello, this is Michael Brown with Avalon Risk Management, your premier provider of insurance and surety solutions for the transportation industry. In our last episode, we covered MAP-21's impact on motor carriers. Today, I will discuss the liability that those who hire motor carriers incur. In particular, when hiring a motor carrier, it is possible for the hiring party to become liable when the motor carrier is involved in an accident that results in a fatality, bodily injury, or damage to third-party property, such as in a bridge impact. There have been more than 100,000 people killed in commercial vehicle collisions since 1980, approximately 3,000 per year. Before going into more detail, it's worth mentioning that while transportation brokers and domestic surface freight forwarders have found themselves involved in these cases on numerous occasions, any party that hires motor carriers is at risk. This includes customs brokers, OTIs, and air forwarders. In the Puckrind case, the Supreme Court of New Jersey found a shipper liable for the actions of a motor carrier that it hired. If your company were to be sued in a case like this, several possible theories could be asserted. The plaintiff's attorney may allege that you negligently hired or selected the carrier. They could also assert that you were vicariously liable for the actions of the driver. Alternatively, they could claim that the driver was your agent or that you were engaged in a joint venture with the motor carrier. Irrespective of the theory that's utilized, if the plaintiff prevails, the judgments can be very large. There are several cases involving transportation brokers that provide some real-world examples of just what can happen. In Schramm v. Foster, C.H. Robinson hired a carrier to transport soy milk from Missouri to New Jersey. The driver, Foster, failed to stop or yield on an exit ramp and collided with Schramm's pickup, resulting in severe injuries. Foster had been driving in excess of his maximum hours. Plaintiffs asserted that Robinson was liable, asserting a variety of theories. C.H. Robinson's promotional materials also made guarantees of covering damage, and the bill of lading erroneously named Robinson as the carrier. The case was ultimately settled out of court. In Sproul v. Henry, a jury awarded $23.7 million in damages against C.H. Robinson. Robinson had hired motor carrier Dragonfly Express, who in turn hired Henry. Henry lost control of her truck in Illinois and rear-ended multiple vehicles, causing 2 deaths. She was operating on a suspended license and had falsified her hours of service logbook. The plaintiffs contended that C.H. Robinson had exercised undue control over the driver, as they had provided special instructions on the load confirmation sheet, such as specific pickup and delivery times, and instructions to have the driver call them with status reports. In Linhart v. Hale, an Oregon jury in 2012 awarded $5.2 million to the Linhart family. In this case, the driver fell asleep under the influence of crystal methamphetamine and struck Linhart, who was parked on the side of the road, killing him. The motor carrier had no federal operating authority or insurance. The authority had actually been revoked for failing to drug test its drivers. The third-party logistics provider, Hale Logistics, was ultimately found liable for the negligent selection of the carrier. In Hoffman v. Crane, a jury in 2012 awarded $27 million to a woman who suffered paralysis as the result of an accident in Iowa. She was struck by Crane, who was returning empty from delivering a load of steel coils. The motor carrier, third-party logistics company, driver, and shipper were all sued under the theories of joint venture and agency. Finally, as the use of technology in the transportation industry continues to evolve with the increasing use of in-cab communications and record-keeping devices, it's worth mentioning a recent case in New Jersey. An appeals court in that state found that a person who knowingly sends a text message to a driver who is likely to read the message can be jointly liable if that driver causes an accident. In this episode, we discuss the liability that can be incurred by those who select motor carriers. Brokers can certainly prevail in these cases, but an aggressive legal defense will be required. Avalon offers the option to purchase contingent automobile liability protection under our combined transit liability policy. This important coverage is designed to provide legal defense and also pay judgments when transportation brokers and domestic surface freight forwarders are held liable when the motor carriers that they hire are involved in accidents resulting in death, bodily injury, or third-party property damage. Brokers and forwarders can also reduce their exposure by having a written carrier selection framework and adhering to it. We will discuss this topic in our next episode. Thanks for watching.